Matter of Dourdounas versus City of New York.
Good afternoon. May it please the court, my name is Brian Glass for George Dourdounas. I'd ask for 3 minutes in rebuttal.
Sure.
Whatever the outcome of this case, I really appreciate the court taking the time to try to help clarify the law so I can advise my clients going forward, teacher clients in New York State, about what their options are when they come with these very compelling fact patterns about their job situations. And this is just one of a series of cases I'm going to walk you through to show how complicated this area has become. I know that there's a lot of procedural things in this case, but the reality of what's happening to these clients is they're coming in and they're governed by a contract, but it's not so clear where their statutory rights fall versus their contractual rights.
Why isn't it where your opponent argues they are, which is you're going to have to show that the union acted in bad faith?
Well, I think before we even get there, there's been a series.
Let's get there. Let's get there.
Well, these clients are in a dilemma by that this is a new area of law that they didn't even argue till after the fact. And the reality is, if you're asking someone who's trying to seek help from the union now to sue the union, so this is a new procedural sophistry I think the city has come up with now recently in cases that was never really the law before.
Your client did proceed before the PERB, correct?
We've taken an option to try through the PERB as well, and we are still pursuing that, actually. We're waiting for the PERB board decision.
Why isn't this AMBAC? I'm sorry.
Go ahead.
Why isn't this squarely AMBAC?
Because what's happened, because there's a series of cases that developed with the teachers as to where, for example, I'd like to go through six cases just to show how this has gotten confusing.
I should go through 6
I'm going to be very quick about it. So, for example, the probationary teachers, it's been settled now that a probationary teacher, regardless of whatever rights they have under the contract, and they do have rights to pursue this, have to come within 4 months, and there's no AMBAC aspect to this. You go within 4 months, you can challenge it. I've been successful in challenging probationary teacher cases within 4 months. So that's very simple. It seems to be clear. We have a simple rule from Katz that the court decided in 2012, Kahn, and that's very, very clear for everyone, and we can follow that. Now, what if you get a U rating? There's also a contractual procedure to challenge that. The courts have made very clear in Brown, which is a First Department case, that you have to exhaust your administrative remedies, and then if you lose, you can go to court and challenge that as arbitrary capricious, and we've been successful on that as well. Again, there's no union, AMBAC, none of this is applying to these situations. Now we get these nuanced cases that are in the briefs, like Katz. What about a substitute teacher who all of a sudden is told you can't be used anymore because there's been a false allegation of corporal punishment? What do you have to do here? Can you go to court right away? Do you have to exhaust your administrative remedies? The city's arguing you have to wait to exhaust your administrative remedies. You can't go to court.
So how about we focus here? We have a union and we have the city, the employer. How does that change things?
Well, all these cases are in the exact same, all these cases I'm mentioning are in the exact same situation. They're all governed by a collective bargaining agreement, but at times...
But counsel, I'm sorry, you're not challenging the fact that in any case you have to exhaust your administrative remedies, right?
Well, I am...
Is that what this case is about, failure to exhaust administrative remedies?
Well, when we've...
But don't go back to the cases just yet. Right here, is there an argument that there was a failure to exhaust administrative remedies, given that the last step of this process wasn't taken by the union, or is that not relevant to your argument today?
Well, we believe we did exhaust remedies to the point that that's why we started the case at the time we did, because we did go through every possible step Mr. Dourdounas could follow to get to a remedy through the contract. And that's what we understand is that some of these cases are seen in certain situations, other than the probationary teachers or some of the things I mentioned, you have to go through these steps.
So the steps that you exhausted were the steps in the collective bargaining agreement?
Yes.
Right? And you got to the last step, and that's then the union decided not to go forward, right? So at least in federal law, the way that would work is you would then allege, at least, that the union breached its duty of fair representation. That would be a necessary element to your claim under the LMRA, and you sue the employer. Why wouldn't that be the same here?
But why would that not happen with a U rating appeal as well? Why would we not have to implicate...
That's a good question.
Yeah,
but if you have a collective bargaining agreement, you have a contract. And you, the employees, not you personally, the employees are the beneficiaries of the agreement. The union stands in their shoes if it sues, right? If it chooses not to sue, then you allege they've breached their duty and you go forward. Why wouldn't that be true for anything that is based on a breach of the collective bargaining agreement?
Because ultimately, they're being deprived of any remedy to ever be heard on the merits. What's happening in these cases is because of the sheer number of...
Why would that deprive you of a remedy on the merits?
Well, did George Dourdounas ever get a hearing on the merits in 8 years now? He's never had anyone, the issue in this case simply was the man was offered a retirement incentive, and he was, no court has ever asked the DOE to answer this complaint at any point in this. He's gone through the union didn't take it to arbitration. He has never gotten to the point to hear, maybe someone just changed the code.
What happened in the PERB proceeding?
Right.
The PERB proceeding, the court has just said, again, we didn't get to the merits because no person testified for the DOE. We've never got a sworn affidavit or anything from anyone from the DOE how that code got changed. The standard, the PERB proceeding was...
I was asking for the result. What?
The
You
PERB
started a
proceeding at the
PERB
first
proceeding.
level, the court said, look, the city can be negligent, but at the end of the day, we're not deciding the merits of whether, the question was simply whether it should go to arbitration. They weren't getting to the merits of what happened to George Dourdounas. In this particular case, George Dourdounas is saying that someone changed the code on me, and I had no idea. So when I took this incentive, I believed that I was an ATR, and after the fact, they're telling me they took away the incentive. We're hearing this in the federal government now, too. They took away the incentive, and he's never had anyone, the city has never responded on the merits to how that code got changed. We don't have a sworn affidavit from anybody. We don't
But
have...
that's the point of the CBA. The union represents him. If the union then, in his opinion, right, in your client's opinion, has failed in its duty, he has an action for that.
And he has tried to pursue that, still pending.
Yes, that's the point.
But the reality is, in other types of areas, like a probationary teacher who's cheated, we can go right to court. So why do we have this dichotomy now that certain types of teachers in certain types of situations...
I'm sorry, when you say go right to court, you don't mean that the probationary teacher doesn't have to exhaust any remedies that are in the collective bargaining agreement?
Yes, but they're governed by the same collective bargaining agreement that George Dourdounas is.
But they do have to exhaust their administrative remedies.
Not at all.
They don't.
Not at all.
They can
The
just
court- the
go
court has said that-
bring
The court
what?
says you can challenge that for 6 years. It's an optional remedy.
And what case is that?
That's the Khan case, that's the Frazier case.
Well, sorry, but that's an interpretation of the collective bargaining agreement there, that those procedures were optional, isn't it?
What do you do with a teacher who has tenure by estoppel, for example? A teacher who has cheated out of their tenure, again, that could be
But
governed by the collective bargaining
Is
agreement.
that this case, though?
Well, these are types of, yes, they're similar in the sense that these are all in the same framework of being governed by a collective bargaining agreement, and you could argue in every one of these cases that there should never be an Article 78 remedy. But the courts are hearing tenure by
Well, it
estoppel
depends
cases.
on the nature of the collective bargaining agreement.
It's all the same collective bargaining agreement, so I don't understand the difference. I mean,
I'm sorry, in your case, in the cases you cited, there was mandatory arbitration?
I'm sorry?
There was mandatory arbitration, and there was a step that said go to the union, and the union then will decide whether or not to go to arbitration?
It's not even clear whether this is mandatory or voluntary in each case, because if you read these decisions, Katz and Campbell-Louis, Campbell-Louis was a case where the woman wanted to rescind her resignation, and the courts, the DOE said, we've brought it as an Article 78, and they said, well, you have to go through your contractual remedies. So she did that. She went through all these contractual remedies, and then and then when she came back, they said, well, you were time barred because you didn't bring it 4 months ago. They're getting into these traps that are very, very confusing. All we would really like to do is set a rule that's very clear. I think the rule should be something to the effect that these teachers should be allowed to bring these valid, assuming it's a valid case, and they have to spend resource on this, so not everyone's going to be filing, but if they feel like they have a very strong case, perhaps the better rule, and some judges have done this, where you could file within 4 months and then it could be put on hold while the collective bargaining process takes effect. So there's no issue of statute of limitations. So perhaps, for example, when you have a year-rating appeal and a probationary termination, you could file the case together. You could wait for the probation, it could be put on hold while you see what happens with the year-rating appeal because it could affect the probationary termination. So I think we're really just asking for a clear rule. This is just one of
A
many.
little confused. Is that the rule you're proposing? Or you're saying this is the way some courts have handled it? And if you're saying the
Some courts-
latter, then what's the
yeah,
rule
some-
that you're looking for?
I think we need clarity to know that if someone, it's not clear under the collective bargaining agreement how it's going to be governed, whether it falls within the collective bargaining agreement, there should be some rule that perhaps you have to bring it within 4 months, but the judge could have discretion if they felt that the other processes of finality would help resolve the case. They can put the case on hold and not worry about the statute of limitations.
If
And
you're
so-
suing an employer for a breach of a collective bargaining agreement, whether it's the union suing or the union's refused and the employee can go forward, why is that in Article 78 at all? Why isn't that just a breach of contract against the union?
Well, we're not really, our beef is not really with the union in these cases. We're
No.
being-
This is a suit against you now. Let's say the union decided to pursue a suit against the employer, right, city.
Yeah.
Why is that not a contractual case? Why is that in Article 78?
Because I think Article 78 allows for the option from arbitrary capricious review under fact. And
This is
that's
a
why it
breach
was
of
created as a-
contract. I mean, you have a better standard, I think, under regular breach of contract law. If they agree to it, they agree to it.
I think there's an ambiguity as to what's really a breach of contract versus what's just simply arbitrary capricious actions. I mean, we're getting fact patterns where people clearly seem to, I mean, I
The
think you could feel from Mr. Dourdounas.
It is a contract, right? The collective bargaining agreement?
Yes, but does it govern everything that possibly could happen to a teacher? And I think
Well,
that's the
it governs
question.
what it says it governs, right?
Well, the contracts are ambiguous. Does it say that you have to,
Well,
you
they're
know,
going to have
if
trouble
you're-
enforcing an ambiguous contract, I would think.
it just raises the possibility that everything would have to
Well,
go
let
through
me
the
ask
contract
you
and there would be no
this.
judicial
What
review.
what your client is complaining of, it's a right he says he was denied. Where did it come from? Wasn't there a contract and agreement that this benefit would be provided to certain persons?
There was an ATR incentive for teachers that was created under the contract. Yes, it was
So it
created
was
under
a
the contract.
contractual,
Yes, and he has pursued that remedy, but then the question is, does he have a separate remedy, perhaps to pursue this as arbitrary capricious? Are you limited to one remedy? I think sometimes.
okay, so you want a plenary action, and you also, you're not saying you don't want to give up that right, but you think he should have the right to pursue it through an Article 78?
I think there could be more than one, you can pursue, frequently what happens is something may have a discrimination case. They might pursue it under the State Division of Human Rights. They may have a PERB case because they were retaliated
Well,
against.
when we think
You could
somebody's
have
brought a
multiple- you could have multiple
contractual, when we think
forums.
somebody's brought a contractual claim incorrectly, it's in Article 78, we can convert them, right? We don't let you proceed both ways.
Well, sometimes it could, but could you have the possibility of a contractual claim and also, let's say you're claiming it's based on discrimination, that he was cheated out of this provision. Is he precluded from, does the contract govern everything that he can't bring a State Division of Human Rights claim based on the same thing?
That's what the contract says, I guess.
The contract doesn't talk that broadly, and so you would basically precluding perhaps any kind of other litigation on someone.
What's the lack of clarity here? And let's talk about this case. What's the ambiguity or uncertainty here?
Well, I think in this case, we would just ask that, once he did exhaust, and we believe that would give us an opportunity, once we exhausted, our reading of the law is that we are allowed at that point to bring a case. And that's, these cases, like Katz and other cases of the nature, have talked about exhaustion remedy. Now the city's been adding this new requirement now, which for the first time, that didn't even argue in the briefs below, as you see, until they even concede that this wasn't even argued, really. And now they're saying, well, you have to implicate your union, which puts the teacher in an incredible dilemma. Now you have to implicate your union now to challenge something that's a very simple employment decision?
Sympathetic to that as a public policy matter, because that's the way federal law works, right? You're bringing a claim under the LMRA, you have to allege that your union breached its duty of fair representation when it decided not to go forward on your behalf.
Well, would we be creating a new rule because, the probationary teacher never had
No,
to
I'm
be
not
barred?
taking issue with that. I'm just saying, when you say, oh, this puts you in employees in a very difficult position because they got to sue to their union, that's federal law.
Yes, I believe in the right case that could be, because you have this alternative option when the beef is not really with the union at all here. Really just the challenging, we want to know why the DOE changed the code, and so the union's interest is really, other than deciding how many cases it could take to arbitration.
If
It has
this
limited
went
resources.
to arbitration, what remedy would you have if you lost in arbitration?
Well, that does change the standard, I believe. There would be a hearing, at least on the merits at that point, of having
In the
someone.
arbitration?
Yeah.
And then you
You'd-
lose.
Well, you could bring an Article 75 to challenge that arbitration if you feel.
Very limited, right?
Very limited, but at least you'd have a chance at the merits.
So
But the way they
going
think-
back to the judge's point, why should you then get this other type of review? Because the union refuses to bring that proceeding, which that's the process
The
on
union-
the CBA, but you would have action potentially against the
The
union
reality
for
is
failing.
the union has like 200 arbitrations a year that they can only bring. If you have 10,000 cases, and you're going to have a lot of meritorious claims that are never going to be heard on the merits.
But
The
but
union didn't.
isn't that a function of what the CBA requires, even if so?
But it's getting to the point that a person is never going to get to the merits of their claim if you have 10,000 cases and the union can only
I
hear
don't
200.
mean to be unsympathetic to
Yeah.
that point. I'm just asking if the CBA requires something, then,
But that's the
Seems to
question.
me-
Does the CBA require it or not in these circumstances? Are they pointing a specific provision that says these particular kind of claims must be must be heard in arbitration? Our argument is that it's not always so clear that the contract governs everything in the world. And that's what I think the concern is
Okay, so
Judge.
now I'm really unclear. Are you saying that this CBA did not provide for this arbitration?
It's ambiguous. It does not talk about this particular situation. It doesn't say that anything
Well,
regarding
it wasn't
the.
ambiguous to your client, because he did seek the union to
Well, if you have a
pursue
union,
arbitration, yes?
Like he's in a union, he has nothing, he doesn't want to pay a private lawyer. What else, he's going to turn to his union and say, what happened?
Well,
here?
that's exactly
So
the point. That's why they enter into the collective bargaining agreement, because they can't afford litigation, so they have the union pursue the grievance on their behalf. And if they don't like it, then they could bring the proceeding. Like the chief said, they could bring a federal action.
But I think the law, how could they bring a federal action? I'm not clear
Or
what.
I forgot what the action we were talking about earlier. There you go.
I mean, that's a very, very limited review that basically says, the union is acting without, they're not getting to the merits of that. That's a situation, just asking if they don't get into the
But it
merits of
then
what
But
allows
understood,
you-
but look, there are benefits to being in a union shop and having a CBA, and sometimes those things perhaps to an individual seem not to be as beneficial as they wish they could be.
could the
But that's part of the trade-off, the benefits you're getting for these other trade-offs, and has already
So
been commented, as you say yourself. An individual might not otherwise be able to afford any representation.
Let me ask you this,
Is
so that-
getting some protections from the union, and if they feel the union is not complying with their duties to the union member, they have recourse against the union.
Let me ask this hypothetically then. So
I
let's
didn't
say,
know we were working in that direction, but
let's say,
I'm open.
let's say you choose not to become a member. Let's say you're covered by the CBA, but you choose not to pay the dues for the union. Would you be entitled to bring an Article 78 under that scenario? Because you're opting out. You're saying that it's part of the bargain you're drawing when you join the union. What if now a lot of teachers are not paying dues in the union because they feel like they're not getting help in these circumstances? So would that person have the right to an Article 78 without exhausting any remedies because they didn't buy the union? They're still entitled to the provision of this incentive, but they're not members of the union. Would they have an opportunity now to just challenge this in court under Article 78 as arbitrary capricious? And you could see why this could be considered arbitrary capricious, the fact that whether it was created by the contract or it was created by any other source,
Mr. Dourdounas, a member of the union?
by default, he was a member of the UFT, yes. So, but again, I do think the law does allow, and I think if you look at these other scenarios where tenure by estoppel, there's people a member of the union, they don't have have to sue the union if they disagree with what happened in the contract. A probationary teacher doesn't like the result, they don't have to go to the union. So there is this uncertainty in the law about when you can go to court and when you cannot go to court. And I think we do need some clarity one way or another. Let's say a paraprofessional, just another one, the last example I was going to say was a paraprofessional. They don't have the rights of a teacher, but they're told they have to go through the process of a due process consideration hearing under the contract before they can come back to court. And so the courts have actually allowed, I've never heard the city argue in one of those cases that you have to implead the union. They exhaust this process, and then there is an Article 78 review. So again, I think we just need a clear rule here, one way or another, regardless of the outcome of this case, to understand, and the city didn't even come up with this argument until after the fact, and because the decisions coming out are suggesting you can go to court, and when can you go to court on these cases, and when are you governed by the collective bargaining agreement? And I can give you multifarious fact patterns,
Your time is actually up,
so
so
I appreciate it. Thank you.
save that for your rebuttal.
Good afternoon, and may it please the court, Rebecca Viscatas for the New York City Department of Education. This court,
What do you believe the petitioner was trying to enforce here? Where did the right come from? Did it come from the CBA? And if it came from the CBA, how does that impact how he can proceed?
It absolutely came from the CBA. That's very clear from the Article 78 petition, which specifically sought to obtain a benefit that was granted under the CBA. That is the only cause of action that petitioner put forth in the Article 78 petition. And it is because of that that under AMBAC, this court's very clear precedent, that he could not bring a claim directly against DOE.
Does the arbitration provision matter at all in your analysis? The fact that there was a potential arbitration step that wasn't taken here, or is that irrelevant to you?
I mean, I think that it is relevant in that because it wasn't taken, that is why he still has an alleged injury to pursue, but then his remedy is...
But what would that injury be? Is that his original injury, or is that an injury because the union didn't bring an arbitration?
I mean, in his view, that is the original denial of the retirement benefit, but in order to... he's incorrect that that has never been looked at on the merits, because what the issue is here is that the union concluded that he didn't have a meritorious claim on that issue. And
So how could he get the merits addressed?
I mean, that was the union addressing the merits,
Well,
and
the
now his
union
remedy...
the union can decide not to proceed to arbitration even with a meritorious claim, right?
Right, but that's where his remedy now has to involve the union and their decision not to pursue that
So
arbitration.
that's the answer to my question is, it does depend on whether or not there's this potential other step. Because let's say the process ended at the step right before that, and he gets this decision and he loses. Would your position be, and there's no arbitration provision in the CBA, would your view then be he couldn't bring an Article 78 at that point?
So by the step before this, do you mean the steps in the grievance
Yeah,
process
the grievance
before
process.
that?
Yeah.
I think
But,
that...
and there's no other potential to get arbitration that's not in a contract, different contract, hypothetical. Could he go to Article 78 from there?
I think, I have to think about that. So if he took it to the union and they...
They grieve, they follow the entire CBA procedure, but there's no union determination, arbitration or not, it's over. Like, we've taken it to whatever official we need to take it to, you've lost, that's the end of the game in terms of grievance proceedings. Can that person now bring in, that employee now bring in Article 78?
I mean, I think that he would still be alleging a breach of the collective bargaining agreement at that point, and would potentially be arguing that the union need to argue and prove that the union breached its duty of fair representation
But
in
what would the
not-
breach be? What would the breach be at that point? They represented him, they zealously represented him, they made these arguments all
Oh,
through the chain.
right.
So at that point, what's the breach?
No,
for
I
them?
think that is the end of the road, and that's what this court said in Ambach.
But Ambach did have an arbitration provision, right?
Yes, but I mean, that's, if there is no arbitration, it's because the union and the employer did not negotiate.
I'm a little unclear here what you're saying when you say the end of the road. You're saying that the CBA only allows, in this hypothetical, you would read it as only allowing the grievance, but not any judicial review. Is that what you're saying?
I mean, I suppose so. I think that would not be a very good agreement between a union and an employer. And so I think that that's pretty far afield from what we have here, because there's no dispute that in cases involving DOE, the CBA has these arbitration procedures, and all of the examples that the petitioner's counsel is bringing up, these are all situations that are largely governed by the CBA, or there are alternative claims that employees may bring that might not be based on the CBA, that may be based on statutory.
But what about some of the examples he gave where he claims you don't need to, you can bring an Article 78, you don't need to employ the union?
Right, so in cases like Khan, the reason why it was not necessary to, why the grievance procedure was optional there was because the alleged violation was not a violation of the collective bargaining agreement, it was of statutory law. And so that is still, in that situation, I think an Article 78 would be available, and it may be that
Right,
there are.
because, and that's, I think, important, because there, you're not bringing a breach of contract action for a breach of the collective bargaining agreement, because the collective bargaining agreement, you said, didn't reach the conduct that was being challenged, it was statutory, and that then makes sense to me why you'd bring in Article 78. But here, where he's alleging, I think you and he both agree, he's alleging a breach of the collective bargaining agreement, I fail to understand why this is an Article 78 at all.
I agree, Your Honor, and I think that I realize that the city has probably been complicit in this, that I think we have been putting some of these cases in the Article 78 box, sort of by default, because they involve a public employer, when a lot of these cases should be brought as breach of contract cases, and would require impleading the union and alleging and proving that they breached their duty
Yes, I
of
think
fair
it's an
representation.
open question, I think, in New York, whether you have to implead the union or simply allege that the union breached its duty of fair representation and then prove that. In federal law, you have to do the latter. You don't actually have to join the union, but I don't think we've ever decided that question.
I think that just in the O'Reilly decision just last year, that the implication of that was that the union does have to be joined. But in any event, at a minimum,
You still have to prove a breach by the union, whether they,
exactly,
yes.
yes. And that's something that Mr. Dourdounas has never alleged. In fact, he has disclaimed that he is arguing that his duty.
Well,
that the
and to
union
my mind,
breached
has
that.
used the wrong procedural vehicle in the first place.
I agree. That is the conclusion that we have come to, and we regret that it was a conclusion we came to belatedly, although I will point out that we did preserve this argument in Supreme Court, and under this court's precedent, that is enough for this court to reach the issue. But after taking a step back and looking at this, we are very much in agreement with Your Honor that a lot of these cases should be brought as breach of contract actions. They would require pleading and proving that allegation involving the union as well.
So which one shouldn't be? You said a lot of these cases.
By a lot of these cases, I mean any case that is alleging a violation of the collective bargaining agreement. And the only cases that would not fall into that would be ones that are also alleging some other statutory violation or something else that does not directly involve interpreting the CBA. But here, that's the only issue, that's the only claim that petitioner has ever put forth. If there are no further questions, we would ask this court to affirm on that basis. Thank you.
Just a couple
Let me
points.
just start with a question. Wouldn't that provide you a lot of clarity?
I believe the judge said that, if they get to the merits, if there is an arbitration, I do believe that the person has a very limited review, they've had their day in court, they've had a chance to contest the merits. What I think the city is saying is that the union gets to decide, the union gets to decide what they think has merit or not, and that's the end of the inquiry. And so that's the problem. The city is never coming forth to give an answer. They're
But
just
isn't
kind
that
of pushing,
kind
pushing
of
on the
the
union.
bargain that was struck on the collective bargaining agreement, that they agreed to this process where if they're going to get a hearing, go to arbitration, which has a very limited judicial review. If they don't do that, the point there is the union decided not to do that, and if they did that in bad faith or whatever, then there's an action against the union.
As we know, the individual teachers are in part of that bargain. That's done on a global basis, so they don't have any say in that. But again, I don't understand.
That's the nature of a collective bargaining agreement, isn't it?
But again, how do we distinguish between the probationary teacher, the para, the substitute teacher, all who don't have any like tenure rights, and the probationary teacher gets to fly right to court and bring an Article 78. It's the same issue. Corporal punishment, I was violated, they violated my rights for whatever issue, potentially subject to the collective bargaining agreement, they can go to right to court. We've always recognized probationary teachers can bring an Article 78 as arbitrary, capricious, bad faith. Why could the para, who has the same argument, not be able to do that? Why do they have to exhaust this remedy? They get stuck on trying to argue that the union didn't take my case to arbitration. Why should the substitute teacher do that?
I mean, you've said that before, and I'll go back to the question I asked you at first. It seems to me you're saying the state of the law is kind of incomprehensible. There are a lot of things that don't make a lot of sense to you. And my question was, why doesn't the process that the city described give you the clarity you want? It might mean some of these decisions are going to now come out differently than they came out before, but at least you'll have a clear rule.
I believe we do need a clear rule, and whether that's, I do think you could still have this, because of the probationary teacher and the U ratings and the cases you'll look at in the past that have been decided on just Article 78 standard, I think that standard should be allowable for these very similar kind of cases like Mr. Dourdounas', which is this arbitrary capricious, independent of the contract. And by tossing them into this contract realm, you're making the standard almost impossible for anyone to challenge a merit-based system and never get to the hearing.
Yes, if I understand you agree there that you want a clear rule, but the rule should be you get to do your Article 78. You get judicial review regardless of what the union decides,
I think there needs to be something.
and regardless of this contract, the CBA.
I think there needs to be some rule that Article 78 should allow some relief when the DOE never comes to the table and explains their interests. They're passing it on to the union, knowing that the union's not going to take it to arbitration because they only have 200 a year when there's 10,000 cases, and so you're depriving people who have very, very serious and real claims from having any kind of judicial review at all because they're just saying, we know the union's not going to do it because they can only 200.
It sounds very much like the union members may want to talk to the union shop leaders about this CBA and this part of the CBA.
Yeah, but I do think that an Article 78 review would not, we do it on selective cases, and it's been working fine until now all of a sudden we're changing the rules, and so we'd like a clear rule, so at least when a client comes in, I can at least understand, if there is a possibility of Article 78 review, because I don't know now, because sometimes it is allowed with probationary teachers, sometimes it is rated with year ratings, and sometimes it's not, and I can't tell someone, what's going to happen when every case comes out different. So I appreciate you looking at this again. Thank you.
Thank you.